what I should do, similar to what my friend did, was to start with the pleadings. I'm going to spend quite a bit of time on evidence after having taken the pleadings, so I should endeavor to do the same. So by way of reminder, the statement of claim, page 16. Point I want to make, but I don't intend to make it in paragraph. There were, of course,
You say page 68.
16.
16.
Oh, I misheard you. I'm so sorry. Thank you.
Sorry. I was about to say, was the accepted fact, of course, is that there were two leaks, 1994, 2012. And at first instance, the case was that both of these leaks had impacted the respondent's property. There was evidence adduced in respect of each of the leaks. And before we even got to the evidence intended to be relied upon in respect of the 1994 and the 2012 leaks respectively was set out in the statement of claim. And so looking firstly at paragraph 25, which is at the bottom of page 20 and goes over to page 21. And at the bottom of page 20, it starts, the contamination of the plaintiff's property caused by the 1994 release was confirmed by tests conducted by the plaintiff as well as by the Ministry of Health's Department of Environmental Services. The test results dated 5th July 1994 and 30th November 1994 confirmed that the water in the private well on the plaintiff's property was contaminated with some form of petroleum product, and that as a result, the water was unsatisfactory for human consumption. The plaintiff will rely on these test results at the trial of this action for their full terms and effect. And so that was the evidentiary basis for the 1994 release. If we go to page 23, well, certainly at the bottom of page 22, just above paragraph 35, you see that there's a caption, the 2012-2013 release of petroleum products at the service station site. So the pleading is now dealing, having dealt with the 1994 release, is now dealing exclusively with the 2012-2013 release. And at paragraph 36, you see where you're setting out, the pleading sets out essentially what transpired. 37, contamination of the plaintiff's property caused by the 2012-2013 release was confirmed by test results conducted by the plaintiff. And paragraph 38 sets out one set of test results, that is the test results confirmed by ADCA Laboratories and Consultants Limited. And then at paragraph 39, the pleading says, further, the results of tests conducted by Adari Engineering and Environmental Services as contained in its report dated 29th August, hereinafter referred to as the Adari Contamination Report, also confirmed the presence of contaminants in the plaintiff's private well supply. The plaintiff will rely on these test results at the trial of this action for their full terms and effect. And so the simple point is this: as it relates to the 1994 release from an evidentiary standpoint, the evidence adduced by the plaintiff to support the fact that there had been contamination of her property as a result of that lease were the 1994 documents. As it relates to the 2012-2013 release, the evidence in support of that contention was what we've been referring to as the Boleg report. And so Boleg's remit was solely in respect of the 2012-2013 release. And the evidence, and I'll just give the references, I won't go to the witness statement.
Because he was the Adari engineer.
Adari, yes, it's the same. That's the name of his company. Yeah. Yes. But he was the one who actually gave evidence. And consistent with the pleadings in the respondent's witness statement, which again for reference purposes at page 255, if you go to pages 262 to 265, you will again see, specifically paragraphs 53 and 54, you will again see from the context of the respondent's own evidence that the Boleg report was in respect of the 2012-2013 release.
Sorry, what am I looking at? Page 255?
Sorry, so you're going, 255 is the witness statement of Lillian Russell, the respondent.
Yep.
And at paragraphs 53 and 54, which are found at pages 262,
260, okay.
The pleading you showed mentioned another report as well. Was that relied on
No.
or not?
no, I mean, it was in evidence, but
It wasn't.
as indicated in the pleading, the reliance was being placed on the Bowleg report vis-a-vis,
Okay.
yes,
Okay.
Sorry, paragraph 55.
53 to 54.
So the ADCA lab results were not relied on?
No, no. And this is the reason why Bowleg then gave evidence. So it is against that background, both of the pleadings and the evidence, that we wish to make the point that Bowleg's report was solely in relation to the 2012-2013 release.
So there was separate evidence about the 1994?
Correct. And if you look at the witness statement of Ricardo Russell, those documents were tendered through him because most of that correspondence and the communications with Texaco at the time was conducted by that the respondent's brother. And so, having said that, if we go back to the Bowleg report, which is at page 978. And if we go specifically to page 981.
Page
981.
981,
The
yep.
report itself starts at 978. It is the paragraph that Leonard Friend had referred to. The suspected source of the contamination is the fuel facility at the intersection of Robinson Road and Old Trail Road, due west of the Russell property. The typical flow of groundwater in the area is towards the north or northeast. Some minor variations. To date, we continue to detect traces of BTEX towards the east of the suspected site. This is following extensive remediation activities at the suspected source site. And of course, the remediation activities that he is referencing specifically on the evidence were the remediation activities after the 2012 spill. So that's the context of his evidence. If we go to his bullet point conclusions, and they are at page 985. And the first bullet point, he repeats that point. To date, following extensive remediation activities by Rubis/Texaco, detected levels of BTEX are present in collected groundwater samples. Constituent parameters, EPA method 826.
Well, sorry, if he's referring to Rubis Texaco,
Yes.
isn't he referring to remediation from 1994 onwards?
Well, there was no evidence of any remediation in 1994, and I think that was an accepted fact. If I can refer you to the witness statement of Mr. Philip Cartwright, and let me get you the reference for that. He, just to be clear, was the manager of the Texaco site at the relevant time. Can you get me the page number? Mr. Cartwright's witness statement while I summarize. So essentially, as the manager of the service station site during Texaco's ownership, what Mr. Cartwright said was he acknowledged that there was an issue, there was a leak in 1994, and he went on to say that there was never any remediation in respect of the 1994 leak. So Mr. Philip Cartwright's witness statement, my lord, is at page 301.
Okay, thank you.
And so in any reference in any of the documents, in any of the evidence to remediation activities are activities that were carried out post the 2012 spill, as per the evidence of Rubis, starting after January of 2023 when the leak was repaired. And so again there,
2013.
2013, yes, January 2013, sorry. And so his second bullet point is that the suspected source of the contamination is the Rubis Texaco fuel facility at the intersection of Robinson Road and Old Trail Road. The source of the fuel spill must be isolated. The contamination has migrated from the source site. So again, this is in the context of his remit. That is vis-à-vis the 2012.
Where do we
2013.
see that that was his remit, apart from your client's witness statement?
And
Do we see it from his report?
no, he
or
doesn't.
His own evidence?
He does not say that, but that is the reason why.
I mean, in his report, he says his task is to measure the contamination, or something like that, I think. If you look at the start of the report,
Yes.
what he says is subject,
And
analysis of,
979, first new paragraph.
analysis of the suspected constituents in groundwater samples.
yes.
He doesn't actually take it as part of his remit, as far as I could see, to express an opinion himself as to when or how that was caused. He just reports that the suspected source is the petrol station.
In relation.
And then he analyses what the levels found were.
Correct. And that wasn't challenged. You know, it was never taken as being a part of his remit to comment at all on the 1994 spill. Not from a pleading standpoint, not from an evidentiary standpoint.
But I think the point being made to you is all he's doing is testing whether there's contamination as at the date of his report.
Correct.
So that's going to cover contamination of this character from any source, whether it be the 1994 leak or the 2012-2013.
Correct. I accept that. And I'm going to get to the relevant excerpt of my cross-examination of Mr. Ramirez. But the point I want to make for present purposes is, and I accept the point because Mr. Boleg said it on cross-examination, that given the fact that there was no remediation after 1994, the constituents of the product from 1994 would still be present. But he also concluded that the property was impacted by the 2012 release.
Where do we see that? That's where
You're going to show us that, is that right?
Well, that is what he says in his bullet points.
No,
He
doesn't.
says that, I'll read it again. Second bullet point. Again, the suspected source of the contamination is the Rubis Texaco fuel facility.
But sorry, forgive me for interrupting you, but he's identified there is contamination, so there are traces of oil, petrol, and so on in the relevant well. He doesn't seem to say whether that's from the 1994 leak or from the 2012-2013 leak. He's just said there is contamination there. And then this is just talking about the source of the contamination he has found.
Well, that is against the background. This is why I started with the pleading and with the purpose of his examination. And that was his conclusion, Lisa, that he was not set on a train of inquiry relative to the 1994 leak. He concludes...
No, but his testing would pick up any contamination that still lingered there from 1994, because all he has done is tested the water in the well.
Correct. And he has concluded, and bear in mind now, he has tested the water in the well, my lord, in the context of why he was retained, relative to the 2012-2013 release and whether or not.
Well, that's your assertion, but at the moment I haven't seen any description of his retainer. I quite accept it happened after that leak, but to say that his retainer was limited to advising on the consequences of the 2012-13 release seems, is your assertion, but I haven't seen where it's made good.
Well,
the fact that when you come to plead it some years later, you use that material for your case under the 2012 leak doesn't really advance matters unless that was his brief.
Well, this is the reason why we refer to the pleadings and we refer to the witness statement of Lillian Russell. That was his brief.
But he doesn't
I'm going to
express any
deal with
opinion.
the issue of the fact that the 1994, because the reality is that from a damages standpoint, what we're addressing on this appeal is the loss of amenity and the award for diminution in value. And when I get to that evidence, which will probably be the last point I address the board on, I will demonstrate that this distinction that we're making is immaterial based on what the witness said. And based on what all the witnesses said. But I just wanted to make it clear, because there was some suggestion by my learned friend as though Mr. Bowleg's evidence was relative to the 1994 release, and that the purpose of him being called was to establish that fact, and it wasn't.
Well, as
That
far as
fact-
I could say, it wasn't relative to either leak specifically. It was just to say what the level was in the ground. And he simply reports the fact that the suspected place where it came from is the petrol station.
Yes, and that the contamination continued even after these remediation activities had been carried out. Right? And so now when we get to deal specifically with the remaining damages issues, I'm going to endeavor to demonstrate that the, as my learned friend refers to it, the evidentiary difficulty, if I can use that phrase, really doesn't arise in light of what the relevant experts actually said and in light of what Lillian Russell said. So, so as it relates to that evidence, I just wanted to put that in context. Now,
Just before we leave the Boleg report, is it fair to say that the reference at page 979, I think the second paragraph in the capital letters, that is Mr. Boleg's summary of what he had been asked to do? Is that
979, which paragraph am I?
I think it's the second, third paragraph down. It's in the capital letters.
The AEE contractor duties?
Duties, yeah. That seems to be him highlighting what he had been asked to do by way of retainer. My question is, have I understood that correctly?
I certainly do concede that that is a description of what he did. But I do maintain the point that for the purposes of his retention, he was being invited to confirm that the 2012-2013 release had impacted the plaintiff's property.
Yes, thank you.
Yes.
I think you were going to show us some evidence of his in either in chief or in cross-examination.
As to?
Well, as to his conclusions in relation to what had happened in terms of contamination from the 2012-2013.
Certainly, we can do that. But what I want to do at that point is to take you to my cross-examination of Mr. Ramirez.
Yes, certainly.
Because the suggestion is that from the appellant's evidence, the substance of the evidence or the effect of the respondent's evidence from Mr. Ramirez was that there was no impact on the respondent's property.
Yes.
And we can see that whereas that is what he said in his witness statement, I will take you to his cross-examination where he veered away from that conclusion. So as it relates to the migration point, if I can move into that, because of course this background is really the precursor to the migration case and the migration finding. So if we can now go to the respondent's written case, and again, the respondent's written case is at 3647. And at paragraphs 9 and 12, that is 3649 and 3650. Firstly, at paragraph 9, I set out the ground of appeal relative to the migration issue, which the appellant had put before the Court of Appeal. And then at paragraph 12, I set out the ground of appeal relative to the migration issue that the appellant now places before the court. And if we can start with, before the board, sorry, if you can start at paragraph 12 with ground of appeal 2. And that's again on page 3650, going over to 3651. The specific grounds that are now before the board, or which the appellant asserts are before the board, are, first of all, ground of appeal 2A. If, contrary to ground 1, Court of Appeal is to be taken as having dealt with the migration issue in Ms. Russell's favor, A, that was a conclusion that was not open to it or the trial judge on the evidence, while Mr. Boleg, Ms. Russell's relevant expert, opined that contaminants found in the groundwater in the property in 2014 had come from the service station. He did not give evidence that this was from the 2012-2013 leak, Rather, his evidence was that contamination from the 1994 leak would have persisted for many, many years. B, further or alternatively, this was not a conclusion that was open to it, meaning the Court of Appeal, or the trial judge, without dealing with the relevant expert evidence of Mr. Ramirez, adduced by Rubis. Mr. Ramirez gave evidence that, one, the property was not in any way contaminated by the 2012-2013 leak. Two, the levels of contamination found in the groundwater on the property in 2012-2013 were negligible and could have come from ordinary domestic activities, a point which was unchallenged by the respondent. However, neither the Court of Appeal or the trial judge dealt adequately or at all with the evidence of Mr. Ramirez, or whether or why it should be rejected, or with the expert evidence generally. So those are the grounds of appeal that the respondent now seeks to place before the board. If we go to paragraph 9, we see the ground of appeal that was in fact before the Court of Appeal, and it was ground of appeal 1C. And it simply says, the learned judge failed to find, as an issue of fact, whether the release of petroleum products from the service station in or about 2012-2013 migrated onto/escaped to the respondent's property at all. Now, I recognize that the appellant is suggesting that that ground of appeal 1C ought to be given a rather liberal interpretation when taken together with grounds 6 and 8. But I think the starting point to that suggestion has to again be Rule 10.3, the Court of Appeal rules, and I think I have invited my junior to send those rules over to the board just so that it's there for ease of reference. And the second point has to be, it cannot reasonably be asserted that the issues that are now raised specifically before the board in grounds 2A and B were put before the Court of Appeal in ground 1C. I mean, even if we were to give ground 1C a very liberal interpretation, and even if we were to conclude, which of course we're not, but for the sake of argument, if we were to say that the effect on a proper construction of ground 1C is an actual challenge of the regulation finding, there would be no way of knowing from looking at this notice of appeal what the essence or the specifics of that challenge were. Was it an evidentiary one? Was it
Well, Mr. Casey says for that you need to look at grounds 5, 7 and 8. Or it is 5, 6 and 8.
Well, and this is the point that I'm going to get to. Well, it's 6 and 8. 6 and 8, again, when you look at them, and my lord, I'm going to get to that in a minute. I'm going to actually take you to 6 and 8. And again, you know, the position that we take in that respect, again, is to suggest that reading 6 and 8 is equivalent or the same as what is now in 2, A and B. We say is again not correct. Because even if you say that 6 and 8 should be read in conjunction with 1C, that is not the same appeal, even if we incorporated 6 and 8 with what is now intended to be advanced by ground 2A and 2B. It's not the same. It is significantly wider, just from the specificity alone, because A and B are identifying very specific alleged deficits on the part of the trial judge, which are nowhere in the appeal before the Court of Appeal. And it could not be suggested that on reading 1C in conjunction with 6 and 8, the respondent would have been alive to the fact that the nature of the challenge being asserted is akin to that which is now in grounds 1, 2, A and B. It just could not simply be the case. And quite apart from that, if you go, my lord, having received, speaking about what the respondent reasonably expected the case at that level to be, the one that she had to answer, you can simply look at the respondent's submissions. And the respondent's submissions before the Court of Appeal.
But just before we get there, I mean, ground 8 has a specific cross-reference to paragraph 106 of the judgment, which is page 202.
Yes. Yes.
And that's the judge's conclusion accepting your submission based on Brown and Dunn.
Yes.
So the complaint seems to be that the judge relied on your point based on Brown and Dunn in order to arrive at his conclusion in relation to migration, and that was an error on the judge's part.
And even if we were to read Brown 8 as saying that, that again is not what is now being proffered by grounds 2 and B, 2A and B. Grounds 2 and A and B still remain significantly wider than that, even if we gave 8 that liberal reading. Which, when I get to my submission...
Sorry, doesn't it live with ground 2A on page 3650 that you've shown us? Because, in effect, that's saying Mr. Boleg did not give evidence that the contamination was from the 2012-2013 leak.
Correct.
Whereas your submission, based on Brown and Dunn, was that the judge was bound to find that it was the source of the 2012-2013 leak was the source of the contamination on the property. Because
a contrary contention had not been put to Mr. Boleg by the respondent.
Right, but if he had not given evidence that the 2012-2013 leak was the source, then I think that the point being made in the notice of appeal to the Court of Appeal, and again in the ground 2A of the notice of appeal to us, was that the reliance on Brown and Dunn was misplaced because he had not given positive evidence himself that the 2012-2013 leak was the source of the contamination.
I'll say this one, sorry.
Yeah, no.
I'll say this one. An assertion that there had been a misplacement or misapplication of the rule in Brown and Dunn is entirely different from a ground that says that he erred in finding, if he so found, that the respondent's property was impacted by the 2012-2013 leak, because the evidence of Mr. Boleg never confirmed that, or never said that, or never bore that out. That's an entirely different ground. That never, ever arose. Because it's akin and similar to the discussion that we've been having, that I've been having with the board for the past few minutes. That is, what is the effect of Mr. Boleg's report? And whereas the suggestion now is that Mr. Boleg's report did not say that the contamination on the respondent's property was the result of the 2012-2000 leak, that was not an assertion on appeal. That was not a ground of appeal. And so now make that assertion, or to advance that ground, when it had not been advanced before the Court of Appeal.
Was it not in this skeleton argument?
Again, it goes back to the rule that I've already provided. Grounds of appeal are not in the skeleton argument. And this is a position that is routinely taken. And when I go back to my submissions, I will show the court where I took it to demonstrate how the respondent interpreted the case that she was called upon to meet. And that is the case that she advanced by way of response to the appeal. That is that 1C was merely an assertion that there had been a failure to find. It did not include, even if we were to read it liberally and include 6 and 8, it did not include a ground that the trial judge had erred by attributing to Mr. Boleg's report a finding that the 2012-2013 leak had been the source of the contamination. No such ground. And so, to the extent that the judge made that finding, rightly or wrongly so, it is an unappealed finding, and it is final. Now, one of the points that, when I deal with the law, I will come back to say, a final finding, and I'm certainly not conceding, a final finding could be wrong in law, but as it relates to these two parties, right or wrong, it is final. Now, the only result of it potentially being wrong is that if the issue arises in a subsequent matter, and someone tried to cite this authority's opposition for something that is wrong, the court on that occasion can say, well, no, I feel as though Justice Thompson got it wrong in Lillian, Russell, and Rubis. But for present purposes, as we're here in this appeal, as between these parties, Rubis and Lillian Russell, any determination that the court made, rightly or wrong, that was not then challenged at the next level is a final finding. And I won't take the court to the authorities that we cite in support of that contention. I'll just give the references at that point. But what I want to do is to...
Sorry, may I just, before you leave the point, just ask you this. If we were against you on that submission, is there any evidence from Mr. Boleg that you would want to point to, other than what you've shown us, to suggest that he did positively give evidence that the contamination that he found on the property was from the 2012-2013 leak, as opposed to the 1994?
So what we will do in that respect, my lord, if the court is against us on that, I will have my junior go through the transcript, because I know that there were questions addressing that point.
Right, yeah, that's
and
what I was asking.
And provide those references.
You've shown us the report, for which thanks. If you had any transcript references, you better provide them to us.
Yes, my lord. And certainly, as a corollary to that, if at the Court of Appeal level, any ground was taken as making that issue live, it would have been addressed at the Court of Appeal level. In fact, a lot of the evidentiary issues and submissions that we heard today were not raised at all before the Court of Appeal. And so it's as though, by way of a ground of appeal, it's as though we're having a whole new hearing of a first instance appeal, of a first appeal of the first instance decision, which of course should not happen. Now, as it relates...
But the complaint is being made that the Court of Appeal didn't properly grapple with a point that had been raised before them. I think that's the essence of the...
And the response to that is, the point had not been raised before them.
Right.
It hadn't.
Your answer to them complaining that they didn't get to grips with the evidence of Mr. Ramirez in the Court of Appeal was nobody made any submissions to them at the hearing before the Court of Appeal about the evidence of Mr. Ramirez.
There was no ground of appeal.
But when you read the three grounds of appeal together,
Yes.
1B, whatever it is, and 6 or 7, what they seem to be saying is that the judge simply didn't make a finding of fact. He didn't engage with the facts. He didn't engage with the evidence. Admittedly, they don't go on to spell out there, but they do in their skeleton argument, that the reason for that was that he took what he thought was a shortcut in law of saying that because Mr. Boleg hadn't been challenged, then as a matter of law, it wasn't open to the defendants to contest the point.
Well, you see,
and
my
that
lord,
was the basis on which he decided it. And he never got to the evidence and made a finding of fact.
And you see, my lord, that is an entirely different point. That is actually what we say 1C says, that he didn't make a finding. And our response was, yes, he did. And the court accepted, yes, he did. So that's the end of it.
So where is the finding that he made?
So, and we start dealing with that issue. Remember, our written case is at 3647. And
what is your best point on the judgment of the trial judge to say, look, he made a finding of fact that in 2012-2013 leak contaminated her property?
okay, and I can respond to that in summary before going into the judgment itself. The evidence, we say, of Mr. Boleg was that it did, the 2012-2013.
So you took us to his report and you showed us that, and then in answer
Right.
to my Lord Sales, you said that's it. So what is there in the judgment?
So I'm gonna go through the steps. That was the first step. That was the evidence that was adduced by the plaintiff in relation to the contamination of her property as a result of the 2012-2013, in conjunction with her own evidence of fact as to the increased, more persistent, more visible smells and odors inside of her home. Then, Mr. Boleg gave evidence. He was cross-examined, and one of his statements in his report, as I've taken the court to, was that the source of this contamination was the service station site, and that there had been migration from the site. Now, I'm going through the steps. I take the point that the court has alerted me to, and I go back to saying, I'm just going through what the judge did, rightly or wrongly so, because it wasn't appealed. The judge then took me up on the invitation to accept the migration point as made by Mr. Boleg in circumstances where it had not been challenged by way of cross-examination. And before moving on, what I will point out there is, and it's a point that we reference in our submissions, quite apart from any other purpose of cross-examination, any point, any contention that a party deems as being critical as a part of their case, if not challenged by way of cross-examination when the witness is in the box, can be taken as being unchallenged. I mean, that's a principle that I think nobody suggests doesn't exist. And the judge then, at paragraphs 104, 105, 106, after setting out all of the various aspects of critical evidence where the assertion was made that there had been no challenge by the respondent, including the migration point, including specifically the point that the 2012 leak had impacted the respondent's property. Ultimately, at paragraph 106, the judge accepted the submission. And when the judge, and I know my learned friend gives an alternative potential construction for the judge's phraseology, all of that evidence must now go to the credit of the plaintiff. We say that, stated alternatively, the judge is saying that I've accepted the case as advanced by the plaintiff in all of these respects.
I think he's saying that fairly clearly in 104, because he says he's accepting it's not now open to the defendant to invite the court to accept a contrary position.
He did say that,
So
and then he went.
conclusion.
And then he went a step further and said that he accepted the evidence. At paragraph 106.
Well, the failure to cross-examine is accepted as evidence. I think what he must mean is the fact that there was no cross-examination on the point means it must be accepted as true.
And he went on to, and actually did that. And again, my lord, I make the point that the question that I'm now answering is whether or not he made a finding, and we're saying that he did. Putting aside for the moment whether it was right or wrong for him to have done so, or whether the finding itself was right or wrong, the only point I'm answering right now is that in the course of those paragraphs, and then ultimately between 104, 105, 106, he accepted the case, the plaintiff's case, the respondent's case on migration, and the impact.
You're saying then that we have to read that as if it had said, but even putting aside Brown and Dunn, I accept, if I'm looking at a conflict of evidence between the parties, I accept the plaintiff's evidence that there was migration.
Yes.
And so where do you get that
Where
from?
does that say?
Because he has accepted it in paragraph 106.
Right.
But that's what he's saying
he
there
says-
is the consequence of failure to cross-examine, isn't it?
The question is whether it is or not.
Because he then, if I were to state it alternatively, my lord, without using the words accepted it as a failure to cross-examine, if I were to use another phrase, he accepted that evidence as being unchallenged.
But
And
what,
so,
what, what
which
evidence?
judges
The
always
evidence
do.
of Mr. Boleg.
Yes. Now, this is the reason why I make the point. Now, I can tell from his lordship's expression that may not have been the decision that his lordship may have made, but the point is that is the decision that he in fact made. And the question is, when you get to the Court of Appeal level, there quite simply is no ground of appeal that advanced the challenge of that finding. You cannot on the one hand say there was no finding and then say that you're challenging it.
You can.
Because you could. Let me state that alternatively. Here's how that would look, my lord. You would have 1C, and 1C would say the judge failed to make a finding. And then subsequent to that, there would be another ground that says to the extent or if and insofar as there was a finding, we say it's wrong because of 1, 2, 3, 4. And there is no such ground. Because how would we know what the 1, 2, 3, 4 is? And 6 and 8 do not provide the 1, 2, 3, 4.
So, do
So
you,
that's-
so-
and-
but I mean, a court has got to come to a decision. At the end of it, someone's got to win and not someone's got to lose. So you've got to decide enough points to identify who is the winner at the end of the day. So if somebody says there was no finding of fact, right, then you've got, the court can't just say, oh yes, there was. They've got to then decide, well, what does that mean for the result of the case? So if they're arguing, they can't be arguing there was no finding of fact, but if there was, then we accept that the finding was against us and we're not challenging that.
No, no, no. I said the
Because then
exact opposite, my
they
lord.
would win the point, but they would lose the
No,
case. They
no,
have to
lady,
be
I said-
arguing a course of reasoning that results them in the winning the appeal, don't they?
No, my lady, I said the exact opposite. I said to the extent that there is a determination that there was a finding, the next ground you would expect to then say that it was wrong, the judge erred in making such finding,
Yeah, but
and
you
here's
say
why I say
they
it was
didn't.
wrong.
You say they didn't make that challenge.
Whereas
They didn't.
They do in their
That's-
grounds of appeal.
They're now doing it now. They're doing it now. And I guess if we were to test the proposition, bear in mind now, as you're standing up in 2022 when you're reading this notice of appeal, you don't have the benefit of the notice that has been drafted in 2024. You're looking at, well, specifically, you don't have the benefit of the present grounds 2A and B. And so you're looking at 1C. And there's no way for a respondent to know or to expect that the nature of the complaint in relation to 1C is what we now see set out at grounds 2A and 2B. And that is where we say that there was no such challenge.
Well, you certainly
Before the
know
court.
by the time you get the skeleton argument that it's the Brown and Dunn point that's being at the heart of the argument.
Well, the reality with that is that even if again, you give ground 8, I think it is, a liberal reading as being a complaint about the rule in ground and done. The nature of that complaint isn't set out. And in any event, I think, I recognize that the nature of the ground now is that the court didn't deal with the issue, but our response is the court dealt with the issue that was placed before it in the notice of appeal. And you see that, we say, in the Court of Appeal judgment.
Where do you see that in the Court of Appeal judgment?
So if we go to the Court of Appeal judgment, and the Court of Appeal judgment is at 1474. Do you have it? And firstly at 1475, which is page 2 of the judgment. Second paragraph, you see the Court of Appeal saying, the judge found that both leaks occurred. They caused damage to Russell's property. The leaks reduced the value of Russell's property, and Rubis was liable for the damages caused by both leaks.
Sorry, this is the head note, yeah.
Yes, and then you go, I'm going to go to the body, but you see certainly from in the head note, there is an acceptance by the Court of Appeal that both the 1994 leak and the 2012-2000 leak were determined by the first instance judge as having caused damage to the Russell property. So that really ends 1C.
That's the law reporter's interpretation of the first instance judgment.
Pardon me?
That's the law reporter's interpretation of the first instance judgment.
That is the Court of Appeal's interpretation of the first.
Well, the head note's not written by the Court of
Well,
Appeal.
it's the law reporter's
And so-
interpretation of the Court of Appeal's interpretation.
And I think it is their
Which I think
interpretation.
it's
21
well, paragraph 51,
or 51 maybe.
page 1495.
Where in the
This is
body
it.
of the judgment?
So now if you go to paragraph 49, sorry, and that's at page 1494. And the reason why I started page 1494, and starting at 49, well, I guess if we start at 48, you see that it's under the caption, the 2012-2013 leak. And 49 really is an indication as to what the Court of Appeal interpreted the ambit of that complaint to be. The fact that it can be dealt with relatively quickly, and they went ahead and did just that. The judge clearly found as a fact that there was a 2012-2013 release. In paragraph 146 of the judgment, the judge states, the court accepts that there were in fact two tortious incidents, a release in 1994 and a release in or about 2012-2013. It should be borne in mind that it was an agreed fact that Rubis bought the gas station in 2012 and that in or about 2012-2013 there was a leak of fuel from one of the tanks at the gas station. And 51, of course, goes on to deal with 1D as we looked at this morning. And so, admittedly, 1C is dealt with between paragraphs 48 and 50. Admittedly, in a quick way, because the Court of Appeal quite clearly is accepting that that is the nature of 1C. With the same sentiment as they did with 51, at 51 with 1D. It's a failure to find ground. And they accepted that there was such a finding. I think we make the point in our submissions that the learned judges, well, the reciting by the Court of Appeal at the second paragraph of 50, referencing paragraph 146 and the judge's acceptance that there were two tortious events, is again...
But they don't engage with the question of whether that was a finding of fact or whether it was in fact based on a conclusion of law that it wasn't open to the defendant to deny it.
Because there was no appeal inviting them to do so.
Well,
it was
how
simply
you read the grounds of appeal, isn't it?
It was simply 1C, that there was no finding, and they determined that there was. And it's the same thing they did with 1D in paragraph 51.
Curiously, they don't even seem to determine what we're debating, that the 2012-2013 release actually caused contamination. They seem to focus on whether there had in fact been a leak in 2012-2013.
Well, I think what they're saying is everyone accepted that there had been a leak, so the only dispute was to whether it had affected Miss Russell's property. But the problem is that, yes, of course, the judge found that there had been migration, and that was the basis on which he awarded damages.
The damages, yes.
But the question is, did he base that finding purely on the Brown and Dunn point, which is arguably wrong, or did he base it on a proper assessment of the evidence before him? Difficult to say, because he didn't really deal with the evidence of Mr. Ramirez and didn't weigh it up and say, well, she said this, Ricardo Russell was only about the 1994. Mr. Ramirez said this, I prefer this person's evidence over that person's evidence. That's not what you see in the judgment.
And, my lady, if I can stop you there, with using that very phraseology that her ladyship used, nowhere in the notice of appeal is there a complaint of that nature, that he failed to weigh up the evidence of this one or the next one in
I thought that's
making
what, 7 or 8 or whatever it is.
6 and 8.
Well, it's 8, isn't it?
8, yeah.
On page 1361, the learned judge erred in law in not arriving at a judgment considering the facts would have reached, misdirected himself at paragraph 106 of the judgment, concluding that he was excused from his duty to weigh and critically analyse all the conflicting evidence. And that's a direct challenge, isn't it, to the judge's application of Brown and Dunn?
Correct, yes. Which is a legal question.
Yes.
But the question that her ladyship just posed as to weighing the evidence and suggesting that the evidence of Mr. Ramirez's ought to have been preferred to that of Mr. Boleg is not the same as the legal question as to the application of the rule in Brown and Dunn. And that's why I keep going back to when you look at what is being submitted now before the board in grounds 2A and 2B, there was no ground that advanced the challenge that is now being advanced. Now, watching my time. I think it would be incumbent upon me, having suggested, and I do it in my submissions, having submitted that all of these findings vis-a-vis Rylands and Fletcher, vis-a-vis the migration issue, were in fact made and not appealed. I should point out to the board, firstly, in relation to Rylands and Fletcher, to the extent that that submission is rejected, the specific responses to the appeal on the Rylands and Fletcher issue are in our supplemental written case, which was sent on the 10th of October, which we rely on. And
so we're moving off the migration point.
no, I'm coming back to the migration point. I'm just going now into, pardon me?
And what are we going on to now?
Sorry, I thought you meant you were moving away from the migration point.
Well, I'm moving now into substantive responses. Remember now, much of my submissions thus far have been that the findings were made, rightly or wrongly so, and they weren't appealed. And so the substantive responses vis-a-vis Rylands and Fletcher are in our written supplemental case.
I mean, it seems to me up till this point, you're really making submissions based on inadequate notification of the case that you had to meet in the Court of Appeal and indeed for us. It seems to me essentially what you're driving at. You're not actually addressing the question whether the first instance judge did or did not err in law in relation to whether he, with regard to the findings of fact that he made. You're not actually addressing us on that.
Well, no, my lord, because we take the position that
Yes.
had that been before the Court of Appeal, that is where we would make those submissions. And of course, because I had been specifically invited by the board to address the submission substantively vis-a-vis the rule in Rylands and Fletcher, we did so upon the board's invitation, and that's the supplemental case. Now,
But these are now points of law about the application of Rylands and Fletcher.
pardon me?
I think these are points of law about the application of Rylands and Fletcher that you're moving on to, as I understand it.
Well, yes.
Yeah.
In
Which is a
direct response, separate.
Which is entirely separate from the question of whether or not migration has or has not been.
Completely different, yes.
Thank you.
Yes. And as it relates, my lord, to there certainly was, before I leave the question of migration, it is incumbent upon me to the extent that my learned friend referenced it this morning, and to the extent that it becomes relevant for the board's determination, the reference by my learned friend to Mr. Ramirez's cross-examination. And you were taken to the various plans, and you were taken to, you were given references for cross-examination. The references were pages 429 to 434.
I think we were shown page 420, or given the reference to page 420.
I think there was a reference then to a number of different pages after 420. But what I want to do, and this again, giving you the context, my lord, the statement that was made by Mr. Ramirez in his witness statement as to the 2012-2013 leak not impacting the property of the respondent. And to support that contention, great reliance was placed on the various plans, two of which we looked at this morning. And the only reference I want to give the board now is an excerpt of my cross-examination of Mr. Ramirez as to how those plans are to be construed and read. And the suggestion was put by my learned friend, and I think it's a suggestion that one would readily accept but for Mr. Ramirez's response. When you look at the plans and you see the outlines, you are assuming, as I take my learned friend to suggest, that that is the extent of the movement of the contamination from the 2012-2013 spill. But Mr. Ramirez clarified that that is not what those lines mean. So if you go to page 432,
432.
432, yes. Lines 11 to 17. Are we there? So this is a question put by myself to Mr. Ramirez, and I say, okay, so let me understand you thoroughly. And again, I promise you, it's just because I want to understand. The outer line, should be line, that orange line that I highlighted, you are not saying that there is no contamination beyond that line. You are saying that at that point, the levels are such that no cleanup is required. Is that what you're saying? And he says that's correct. And so we made the point that whereas the plans had been suggested and presented,
Which
as
plan and line are we looking at? Yeah.
the plans that we were in the Black and Veatch report,
The plan we were looking at, same one we were looking at earlier.
the same one we were looking at earlier, yes.
So which is the orange line on our plan?
Well, regrettably, at the time,
No,
they were
but
in
you-
color.
I know I haven't got it in colour, but
It's the outer line, because I do say in the outer line. And I think the point was made earlier that the outer line, of course, is before you get to the Lillian Russell property, to the respondent's property, sorry. With the
Is the Black and Veatch testing and the orange line, is that, I think the judge then asks, is that as of October 2013? Now, had any remediation been done between January 2013 and October 2013?
Absolutely,
Yes.
extensive.
Right. So what Black and Veatch are measuring then is the levels of contamination after there has been remediation by the company of the league.
Correct. And the judge makes that point in the judgment. The fact that the levels may well have been higher prior to
Where
the...
does he make that?
I'm going to let my junior pull that. Where he makes the point that the levels may well have been higher. So, my Lord, wanting to move on, well, as soon as I get that reference.
So is the purpose of the Black and Veatch report to say they've done all the lots of remediation, let's see whether it's worked or whether we need more remediation?
Correct. They were the regulators, I guess, the report on behalf of the regulators to ensure that what was being done, almost like a watchdog for what Rubis was doing. There's a remediation report in the evidence that was Rubis's, and then Black and Veatch as an overseer to ensure that what was being done was in fact done.
Is this right, that there was no evidence before the court as to the levels of contamination on Miss Russell's property between January and October 2013?
Correct. And certainly bearing in mind that Mr. Bowleg's testing was August 2014.
Yeah, and when was Mr. Ramirez's testing?
I have to check.
Maybe later, isn't it?
There are, all in 2013, certainly, at 3 different points, ending in October, I think. But I'll find that for sure. I know that there were 3 different testing dates conducted by Arcadis, that is Mr. Ramirez's company, and they're all in 2013, at staggered junctions.
So then what you just said was not right when you said there was no evidence before the court as to tests carried out?
The question was on Miss Russell's property.
Oh, okay.
Yes, on Miss Russell's property, yes.
Were Black
If
and
I-
Veatch the first, or
Pardon me?
were Black and Veatch the first to test, or not?
No.
No, they weren't. Okay.
What I want to do at this point is to move on to the damages issue. Before doing that, I would just provide the references on the cases that we rely on relative to the treatment of findings and determinations that have been canvassed at first instance, rejected or determined, and then not appealed. So there are 3 cases for that. I'll just give the references. There is a case at page 4679, and it is R on the application of Friends of the Earth Limited and another, and the Secretary of State for Transport. The relevant section is paragraph 113, which is at page 4716. So that's 4679 at page 4716, paragraph 113. The second is Preston and Beaumont, which is at page 4763. And the relevant portion of the judgment is at page 4766. And finally, Tombstone and Tameside, and that is at page 4922. And the relevant portion of the judgment is at page 4955, paragraph 78.
Paragraph?
78.
78.
78.
Thank you.
Yes. At page 4955. As it relates to the question of damages, and we address this at paragraphs 111 to 139 of our written case, and I don't need to go to the authorities. I'm sure the authorities and the principles are well known. But we make the point that relative to the invitation to set aside the judgment of the Court of Appeal or any portion thereof, we say that the requisite criteria for the court to accept such an invitation has not been set out by the appellant, and that in any event, the award is certainly not inordinately high, having regard to the circumstances.
Certainly not.
Inordinately high, sorry. And in any event, the evidence demonstrates the reasonableness of both awards. And again, the rewards are the reduced amount of $25,000 for loss of amenity and the $131,000 for diminution in value.
And
so if I could...
You haven't challenged on cross-appeal the dismissal of the remediation costs?
We haven't, no. We haven't cross-appealed at all. We believe in the finality of litigation. So if we could look at those portions of the evidence firstly. So I don't need to go to paragraph 74 because we looked at it this morning. This is paragraph 74 of the witness statement of Lillian Russell, where she speaks of the increased effects of contamination after the 2012-2013 spill. And
wasn't there somebody else who also gave evidence about contamination, or was that just Mr. Russell and that was just...
Mr. Russell only spoke about 1994 because at the time of 2012 he no longer resided at the property. So it was just Lillian Russell, the respondent herself. And certainly from a loss of amenity standpoint, we say that you have the court taking into account the correct legal principles in the sense that having rejected the respondent's claim relative to the 1994 spill and having made a determination that a large component of $250,000 for loss of amenity, which had been awarded by the learned judge, took into account the period prior to 2012-2013. We say that in light of the fact that there was evidence of the effects from a loss of amenity standpoint, certainly there was sufficient evidence in any event to warrant the $25,000 award that was ultimately made. And I should point out that quite apart from paragraph 74, there is also evidence of Lillian Russell that she left the property for this very reason. And certainly the fact that one leaves their property.
So I'm just looking at her witness statement, paragraph 51 at page 263.
Yes.
She says, on the 10th of April 2013, a private well was converted, outfitted as a monitoring well, and you could smell the gasoline.
Yes.
Right. And that is presumably before remediation had happened.
Yes,
Yeah.
yes. And she also makes the point that paragraph 52, as of June 2013, after having reverted to city water, the water bills were paid by the appellant. And subsequent to 74, '78,
Did anybody ask them why, in the trial, why they had paid her water?
well, the reality is that the appellant only provided one witness at trial, which was an expert witness, Mr. Ramirez. There was no witness of fact provided by the appellant. So there was no one to put that question to, if I may put it that way. And so, based on the evidence from the respondent, we say that there certainly is sufficient evidence to form the legal basis for an award, for the reduced award. And certainly, we say it cannot be suggested that it is unreasonably or inordinately high in light of the evidence that was proffered. Now, as it relates to the diminution in value, the evidence, of course, that was adduced in relation to that component of the claim was from another expert of the respondent, that being Mr. Wilshire Bethel. And his report is at 998. But I want to go to his examination in chief, which is at pages I'm going to take you to pages 372 to 374. And the reason why I want to go to this, because
you accept as a matter of principle the cases put against you in Performance Cars and Abraham and the like, that we are, insofar as there was damage being caused or diminution in value being caused by the 1994 leak, that can't be claimed.
well, the portion of Mr. Bethel's evidence that I'm about to take the board to demonstrates that the diminution that he speaks of is in relation to the 2012-2013 leak.
Yeah, I didn't ask you that question. The question I asked you was, as a matter of principle, if it's clear that the diminution in value was attributable to the 1994 leak, you can't claim damages for that diminution in value.
Oh, I would accept that.
Yeah.
And I'm taking you to the evidence to say that it wasn't attributable to the 1994 leak. Whereas in the pleadings, the assertion was that the diminution, the evidence of Mr. Bethel, was to be in both respects. His evidence actually was relative solely to what occurred in 2013. And if we can start at we should perhaps go to the report itself to start off with. So the report is at 998. My apologies, I'm going to go to the report first and then go to the... And in the interest of time, I will merely give the references in the report. Page 12 of the report itself, the records page 1008. And that is the notation at the bottom. And then at page 16, where he introduces the concept of external obsolescence. Sorry, the 16 of the report, 1011 of the record. And the point that I make before going to his examination in chief is that from an evidentiary standpoint, the diminution in value in which he gave evidence on was in respect of what occurred in 2012, 2013, which was well known to the public and in which the government had intervened. There was no such activity in 1994. And he speaks of this in his examination.
What are we looking at?
So 372, this is now the examination in chief of Mr. Wilshire Bethel. And I'll just give the range in the interest of time, 372 to 374.
So is this the point that the diminution in value came about because everyone had heard of this terrible leak of petrol from the service station, and no one would want to buy a house near there unless it was at a substantial discount?
Correct. And that is
That
the
isn't
concept
good
of
enough
the...
for a claim, though, is it?
Pardon me?
You've got to show the diminution in value came from damage to your property.
Well,
There's some case law on that, saying that it's not enough to say that the value of prices have gone down because something's happened in the area.
well, two points. He attributes the diminution in value to the concept of external obsolescence, which he describes at page 372.
Okay.
And then,
sorry, external obsolescence.
Yeah.
What is that?
it's in the report,
Yep.
but then he explains it. Let's start at page 372, starting at line 6. Do you have it?
Yep.
Okay. So this is him speaking now. Yes, whilst carrying out my inspection of the property, it would have. I went in late afternoon before or early that morning before I arrived. Upon arriving at the site, I carried out an inspection of the building. I observed, first of all, the ground was damp, wet, and it was obvious to me the smell of oil on the property. Of course, I bent over to do a close observation of that condition, and it was very, very clear that there was a distinct smell of oil on the property. Now, I want to refer you to page 16 at the bottom. There is a phrase, external obsolescence, and that's the portion of the report that I just referred to. He says, yes. I say, what is meant by external obsolescence? He says, well, external obsolescence is clearly defined in that portion of the depreciation page. It identifies things of an environmental or economic or locational consequence. It identifies any losses in value caused by any of those matters, environmental, economic, or locational. Did any issue of external obsolescence play a role in the preparation of your opinion in this report? He says, well, the report itself identifies the building in its entirety, and of course, in carrying out that one has to be physical, functional, and external obsolescence in its very nature under continuation. What factor, if any, did you take into account as being relevant in the context of external obsolescence? One, the fact that I think it was a known fact that there was an oil spill on the property across the street from this property. And obviously I wanted to make up in my mind a clear determination as to whether there was anything on that property that would affect my determination of value. And did anything on that property affect your determination of value? Oh, definitely. There was originally the perception that because there was the oil leak, a known oil leak at the Rubis across the street, and of course the general concern that with government at the time identifying along with other environmentalists that people should move out, my concern was to determine whether there was anything relative to that oil spill that has an effect on the purpose of my being there, which is to determine the market value as a result of that. I then said, what was your determination in that regard? Well, the value of that property was, my opinion at the time really was, the value of that property was in free fall. The value of the property was dropping. And the perception of danger to someone economically as a result of being there actually had an effect on value. And I want to refer the remainder of paragraph 374, where he goes on to then say how it is that perception, based on what was happening in 2012, 2013, that caused him to assess the diminution in value. And so
the is that at lines 17 to 19 on page 374, he is comparing, if there were no adverse condition, the value would have been 225,000. I think the case put against you is that there was already an adverse condition.
Well, my response to that would be this, my lord. The nature of external obsolescence, as he's defined and explained it, it's not the mere fact of the occurrence of an adverse condition. It is the knowledge of it to the potential buyer. The knowledge of it is that what creates the perception, the concern, and the change in the amount that a willing purchaser would be prepared to pay for the property, and thus the value. So it's not just the fact that something happened in 1994. It would only affect value if the public at large and people were aware that something had happened in 1994. And he specifically spoke about the activities, when you go back to 373, sorry, the governmental activities, the government advising people that they should move out of the area. These are the things that he took into account. These are the issues that he said affected value and how he arrived at his determination as to the diminution in value. So the point is, even though the Court of Appeal rejected the claim relative to the 1994 spill, this witness who gave the evidence as to that assessment of 131,000 did it on his own admission based on what was happening in 2012, 2013. And so when the Court of Appeal in paragraph 65 says that there's nothing that prohibits them, or they could take the diminution in value as being attributable solely to the 2012-2013 spill, the evidence of the witness himself supports that conclusion. And again, we go to the point where you look in the transcript at the end of his evidence, that is at page 374, lines 24 to 32, he wasn't challenged, he wasn't cross-examined at all. And so you have to take everything that he said from an evidentiary standpoint as unchallenged. And I'm not saying that you, or that the court should apply the rule in Brown and Dunn. What I'm saying is that this evidence is wholly unchallenged.
The thing is, he's not distinguished there between diminution in value that results from the fact that the petrol station next door has had a leak, which doesn't give you a claim, and diminution in value which arises from the fact that your property has been damaged, which does give you a claim.
Well,
and his damage seems to flow from the first.
and I go back to the grounds that were before the Court of Appeal. The Court of Appeal was dealing with what was before them. And there was no such challenge to that claim. Ground of Appeal 10, in the Notice of Appeal, again, very nuanced complaints, none of which included the complaint that is now being made. Because if that complaint were being made back then, we would have addressed it. And so, my lords, I'm being told that I have 2 loose ends. Oh, okay, yes, my lady. Relative to in the judgment where the trial judge referenced the fact that that critical period prior to the the remediation exercises, it's paragraph 71 of the judgment. The page number? 151. Okay, and the other loose end that my junior is pointing out, the Court of Appeal apparently gave extensive consideration to, well, discussion during the hearing as to the extent of the remit of Mr. Bowleg, and that is at page 2093 to 2094. Anything else? And so, my lords and my ladies, unless I can be of any further assistance, those would be the submissions. And of course, we rely also on all of our written submissions. I have an additional 5 minutes that I'm going to give to my learned friend.
Fine. just before you sit down, I just
Yes.
want you to, your confirmation that your Leonard Jr. has been through the transcript to see if there's anything positive said by Mr. Boleg about the effect,
That would be the
positive
trial
effect of the 2012-2013 spill, and that there isn't anything further on which you wish to rely.
We need to do that. That would be the trial transcript. So, yes. So that's volume 1.
So you told me in answer to one of my questions before that your junior was going to check. I just
Yes,
want to,
and he will continue to do that,
confirm.
Lord,
All right.
and hopefully before we rise.
Yes, all right.
You can
As long
provide.
as you confirm one way or the other before we rise, that's all I'm asking for.
I'm obliged, my Lord. I will assist as well. Thank you, my Lord.
Thank you.
My lords, my lady, can I deal first with the point in relation to the Rylands and Fletcher aspect of the case, and as to whether the grounds on which we now rely are new grounds, and if any of them is a new ground, whether nonetheless we should be permitted to advance it before the board. Starting with the meaning of ground, Court of Appeal ground 1D. So ground 1 obviously starts with the introductory wording at page 1358. And continuing that through to 1D at 1359. But the learned judge failed to find as a matter of law and issue of fact whether the operator of the service station, Fiorente, was liable in whole or in part in relation to the 2012-2013 release. We submit that given a fair and proper reading of that ground, with knowledge of the relevant background, one would understand that the point being raised is that for any Rylands and Fletcher liability, the correct defendant would be Fiorente, not Rubis, for the bases that we saw, on the basis that we saw pleaded, that Fiorente was the tenant under a lease, Fiorente was the occupier of the site, Fiorente was the owner and controller of the dangerous substance, the fuel. Now, a number of points. First, we can see that that's how the Court of Appeal understood this ground, starting at page 1772.
Sorry, 1772.
1772, my lord. So we're into the Court of Appeal transcript.
Ah,
Oh, right.
Sorry, the transcript of argument in the Court of Appeal. There's a number of points, related points here, but starting at 1772, line 17. Mr. Hanna for the appellant. We've submitted that in the context of the alleged 2012-2013 leak, the proper party for the purposes of the action would have been Fiorente. Fiorente was the actual occupier of the premises in question, and Fiorente was the party that brought the substance onto the premises. We say the law is clear that where a claim of nuisance is brought, the proper party against whom it should be brought is the actual occupier, and reference to the St. Anne's Well case, which had also been referred to in the skeleton. The board may remember was the case about the collapse of part of the city wall of Exeter. And whether the landlord who had been sued was potentially liable for that. Then over to 1773, at line 10, Madam Justice of Appeal Crane Scott asked which ground are we on, and Mr. Hanna said 1D. And then Line 14, Mr. Hanna explained that the judge failed, explained that as it were what the ground said. And then at line 18, the President, your case is that in 2012 Rubis was simply a landlord. Yes, and the fact that it was a landlord of property from which the leak occurred doesn't make it, as the landlord, liable for the leak. Correct, my lords, that's your case. And then over the page, yes, in simplest terms, yes. Madam Justice Crane-Scott, this is only in relation to Rylands and Fletcher, and he says it applies to Rylands and Fletcher and also negligence and nuisance and so on. And then taking it slightly further down, 1774, line 20, the President, and therefore, even if a leak occurred from the property of which it was the landlord, that Rubis as landlord cannot be liable under any theory pleaded in the case. That's correct, my lords, that's our position. Over the page, that's your case. And 1779, top of the page, line 2, again, Mr. Hanna saying, explaining we're still talking about ground 1D. And then line 16, the President said, but there's no analysis in the judgment as to whether or not that contract, the lease, is simply a contract between the lessor and the lessee, and whether or not that contract gives Ms. Russell or anyone else a cause of action against the lessor. Line 22, at first blush, the proper analysis is that you have to sue the owner and occupier of the property. And if that owner or occupier has a claim for indemnity against the landlord, he can bring his landlord in. So we submit that it is relevant that, that when one's looking at the meaning of ground 1D, that it appears from the argument that the Court of Appeal clearly understood it to have the meaning that we say that it bears. It's also relevant to note, for the reasons I'm going to come on to, if I need permission to raise the ground now, that the Court of Appeal was apprised of the authorities on which we now rely. St Anne's Well, also Smith and Scott and Transco, and I can give the board the references for where they were picked up in the Court of Appeal skeleton argument for the appellant. Paragraphs 6.6 through to 6.14, pages 2193 through to 2199.
I'm sorry, that's what document you did tell us?
That's our Court of Appeal skeleton, my lord.
Thank you.
And
was the argument made against you or your clients in the Court of Appeal? No, you can't say that because it's not what you put. It's not what your grounds of appeal mean, and it's not open to you to advance this argument.
I think that was indeed
that was the argument.
Yes. And I would need to check, but I don't want to give an offhand answer, but I don't think that the points were dealt with as a matter of substance. As it were, that's the level at which the argument was put, not open.
Same level as it's being dealt with here, basically.
Yes. Now, if we're wrong about that, then we submit that in the light of those points and what one sees in the Court of Appeal judgment at paragraphs 51 to 53, back to page 1495, the board will remember that discussion with my learned friend about the sort of sequence between paragraph 51 and then paragraphs 52 and 53, where at paragraph 51, the Court of Appeal does indeed appear to be accepting a point about the drafting of ground 1D, but then at 52 to 53 goes on to deal with the substance of the point. We submit that, well, firstly, that the Court of Appeal has dealt with the substance of the point that was argued before it, and so it can't be said that it's a new point before the board. But on any view, if on some theory it is a new point because the board accepts that ground 1D before the Court of Appeal should be read in this very constrained way, then we respectfully submit that it would be an appropriate case for us to be permitted to raise the point now, the correct defendant point. Because on any view, it's clear that the point was argued below on its merits fully. The Court of Appeal has given its views on the merits of the point, albeit in succinct terms. And looking at the test in Baker and the Queen, as recently encapsulated in Attorney General and Reed, and for reference, the page references for the relevant passages are 3795 and 3778, respectively. We do submit that the nature of the argument here is such that the outcome doesn't turn on an appreciation of facts or evidence. These are, we submit, my Lord Burroughs was correct to say that these are pure points of law. And as I say, if technically new points, only in the most technical sense, given the extent of the argument about them below, the fact that relevant authorities were canvassed, and the Court of Appeal has given its views.
It's critically dependent on the facts, but it's not dependent on disputed facts.
My Lord, yes. And really what one sees from the judgment of the Court of Appeal is the Court of Appeal said, well, there's nothing in this point because under the lease, the lessor equipment, they use the shorthand, the tanks, were not leased. And we say that's a simple error in terms of the...
I mean, the facts are all in the lease, really, aren't they?
Yes.
Well, but we don't know that. Suppose the lease had said, oh, Rubis, you're entirely clear, it's entirely clear that you're the ones who've got to maintain the tanks. But in practice, the lease said that Fiorente is obliged to maintain the tanks and monitor. But actually, when Rubis went along, they said, you don't touch the tanks. The tanks are for us. We'll send in our contractor, and we don't want you messing with the lines. Then you couldn't just look at the lease. You would have to look at the facts on the ground, wouldn't you, as to what actually happened?
My lady, had there been evidence of that type, then I agree, but there wasn't.
Well, there was no allegation at that time either.
There's no allegation.
I mean, the lease was pleaded, and nobody said, well, actually, it's not how it worked in practice.
No. It was said that it all follows from the lease. Yeah. And there was no evidence, if I can put it this way, adduced by the respondent to the effect that, oh, well, it doesn't matter what the lease says. At a ground level, things were different, and Rubis was there all the time, and Rubis had essential control and occupation of the tanks. It was clear from the lease that Rubis had the repairing obligations in relation to the lessor equipment, including the riser pipe. And not only an obligation, but the lease said that Rubis is the only party entitled to repair those parts of the equipment. One can see, obviously, why someone in Rubis's line of business would want to have that. But we say that the case law makes it quite clear, in the context of occupier's liability, that that type of provision doesn't make the landlord an occupier. And we submit that, as a matter of logic, it's hard to see why a different result should obtain in the context of Rylands and Fletcher. But my lady, it was dealt with very much as all flowing from the terms of the lease. The Court of Appeal said erroneously, oh, well, the lessor equipment hasn't been demised to Fiorente.
I take your point.
Now, a number of points, if I may, on the migration issue. Firstly, as to whether this is a new point. My learned friend took you to paragraph 9 of the respondent's written case, which is at page 3649. But with respect, which obviously cites ground 1D, but with respect, what she fell into the same error that the Court of Appeal did at its paragraph 48 at page 1494. So I took the board to paragraph 48 in my submissions this morning, where the Court of Appeal said, with respect to this leak, Rubis complains that, and gives one of the migration issue grounds and then 2 Rylands and Fletcher grounds. And as I said earlier, what the Court of Appeal appears to have done is simply to have overlooked the grounds, Court of Appeal grounds 6 and 8. Which are at pages 1360 and 1361. The board's obviously looked at them a number of times. But those are the grounds which, in terms, complained that in dealing with the migration issue, the judge didn't grapple with and didn't weigh the conflicting evidence and made a determination based upon Brown and Dunn at paragraph 106, erroneously didn't, as it were, discharge that part of the essential function of the judge. And my learned friend, I think, simply hasn't dealt with that omission and the failure by the Court of Appeal simply to deal with those grounds. In terms of those matters being argued before the Court of Appeal, can I show the board firstly pages 2090 to 2091?
So is this transcript to the Court of Appeal hearing?
My Lord, again, this is transcript of the Court of Appeal hearing.
And who is speaking in this section?
Now, this is Mr. Hanna for the appellant. And 2090 my Lord, picking it up at line 19. Mr. Hanna said, why I wanted to tie in the decision of a particular reference to a case. My learned friend has suggested, as I understood it in her submission, that the expert report of Mr. Bowleg made or submitted some form of expert finding that there was a leak in 2012. I looked at it again, and I would stand to be corrected by my learned friend, but I haven't seen and continue not to see any reference by Mr. Bowleg in his expert report that there was a spill in 2012 which impacted the property of the respondent. And now the court accepted, we submit, that there was some impact on the respondent's property, but there's no distinguishment between whether this occurred as a consequence of the alleged 1994 leak or as a result of the alleged 2012 leak, sometime in between or by some other cause. And then 2091, lines 8 to 13, we say the finding of the judge in relation to the expert evidence of Mr. Bowleg's unsafe in part, for numerous reasons, but in part because Mr. Bowleg's evidence doesn't make a determination or a finding that the impact he cites arises from the alleged 2012 leak. So precisely the point that we continue to make now, and the point obviously that arose from grounds, one of the points that arose from grounds 6 and 8. Can I also show the board, I think I mentioned them earlier, but can I show the board, firstly page 1954, which is still in the Court of Appeal transcript, but now the submissions of my learned friend. Page 1954, lines 10 to 16. My learned friend said, so essentially with grounds of appeal 6 and 8, the gravamen of the complaint is that the learned judge failed to consider conflicting evidence, meaning evidence that was adduced by the respondent on expert issues, expert testimony, vis-a-vis that was adduced by the appellant, and to, I guess, reconcile and demonstrate why it is he preferred the respondent's evidence to that of the appellant, and then page 1955, foot of the page, line 25, the only conflict on the expert evidence that arose, as between the respondent's witness, Mr. Bowleg, and the expert witness of Mr. Ramirez, was one issue. And there's one conflicting issue is whether or not the 2012-2013 spill impacted the respondent's property. So when you read in these ground of appeal number 6 and number 8, this whole issue of conflict, the only conflict there was whether or not whether there was a spill in 2012, but whether or not the 2012 spill impacted the respondent's property. That's the conflict the appellant is by ground 6 and 8, complaining the judge didn't properly analyse. So it's precisely our point, that's how it was understood, simply not dealt with by the Court of Appeal. And my learned friend said, well, it wasn't apparent to the respondent as well, this was the nature of the point being taken. Well, we submit that that's plainly wrong, and indeed, at page 2094, again, staying within my learned friend's submissions in the Court of Appeal, lines 4 to 15. One sees my learned friend making precisely the same submissions that she's made to the board in terms of the argument that Mr. Bowleg's report should be understood as dealing with impact caused by the 2012 leak. So using the same phraseology, he made it quite clear that his only remit was to give evidence on the impact of the 2012 spill on the plaintiff. In fact, she was wrong to say that he said that in his evidence in chief. He didn't say that. But this was my learned friend making the same point, that Mr. Bowleg's evidence should be understood as being directed to the 2012 leak. And indeed, she had referred to the statement of claim, for example, as the board has heard today, as being somehow informative on that point. So we do submit that the suggestion that there is, in our appeal to the board on the migration issue, a new point that wasn't aired before the Court of Appeal is simply wrong. My lady asked a question about what the data was before the court about dates of tests. My lady, it might be convenient to look at page 3646, where we've set out a table in the annex to our case that gives you the data that was in the documents before the court about tests and dates. It is indeed correct that there was nothing in relation to MW47 earlier than 23rd of October 2013, but the board has the...
And you accept that that was after there had been substantial remediation?
We accept that that was after there had been carried out on the service station site substantial remediation. My lady, yes, there was quite a lot of evidence about what was done. trucks coming in and vacuuming things out of the ground and so on.
But it's just that when you showed us those zones in the Black and Veatch report, I understood that you were showing us that those were the scope or the outlying boundary of the contamination that had been caused by the 2012 leak. But now I understand that's not actually what those show. What they show is that that was the boundary of what remained of the leak after however many months of remediation work. Is that fair?
Well, my lady, certainly what remained, including off the site, after there had been remediation on the site. There wasn't any exploration in the evidence of whether remediation on the site would significantly reduce any contamination in unremediated land off the site.
So we don't know whether it would have done or not.
We don't.
And Mr. Ramirez didn't express any view about what the results that he got showed about what had actually happened, as in April, May 2013.
My lady, that's right. No one tried to, as it were, do
Reverse engineer.
a reverse calculation, as it were. We'll sometimes get in drink driving cases and that sort of thing. No one did that in relation to this. But my lady, in case it's of assistance, page 3646 shows the evidential sources and the dates and the readings. Very briefly on what we've called the damages issue. We submit that the board doesn't derive assistance from those authorities that say that an appellate court should be slow to interfere with a judge's assessment of damages. Our complaint isn't that the Court of Appeal was in a position to make an award of damages but erred on the high side. Our complaint is that the Court of Appeal wasn't in a position to make an award of damages at all. And so we're not, I hope, seeking to infringe the principle of appellate caution referred to in those authorities. One very small point, if I may. My learned friend said that the evidence was that the respondent left the property because of the contamination. And it's just quite important to see how her evidence on that was, it seems to me, quite careful and limited. It's at page 268 in her witness statement. Paragraph 78. So what she said was, ultimately in 2016, I decided to move away from the property, partly because of my realization that the property remained contaminated and that it had been further contaminated by the 2012-2013 leak. I since rented the property, and on each inquiry by potential tenants, I was asked about the impact of the 2012-2013 leak. My response to them has been honest, specifically that the private well supply had been affected, but that the property is currently using the government water supply. This issue has undoubtedly been a concern for the tenants. So the point that I make is that she didn't say, quite fairly, and as I say, this looks like quite a careful piece of the evidence, she didn't say, I had to move out in 2016 because of noxious odours and because of problems of that nature. Rather, it was because of partly because of her realisation that the property remained contaminated. It didn't say...
Well, this was 3 years later, anyway, after the leak.
My Lord, it is indeed. It was simply there was a suggestion, as it were, that the as I understood it in my learned friend's submissions, that the deleterious effects of the contamination forced her out of the property. It seems to be a different point that's made, and she doesn't say, for what it's worth, that she ever had any problem renting the property out, or that she had to accept reduced rent, and there was no claim of that nature made. And her answer to tenants wasn't Well, the impact is the smell that you can detect, which I'm afraid I can't do anything about. Rather, her answer to the tenants was, well, the well can't be used.
Is there some implication there to which we may be insensitive that there's something wrong with the Bahamian government water supply?
What was the question? Sorry.
I think I'm probably not best placed to answer that.
What was the question?
The question was, what she says is, I was very honest to the tenants, specifically the private well supply had been affected, but that the property is currently using the government water supply. This issue has undoubtedly been a concern for the tenants. But my question is, would someone in the Bahamas reading that understand, oh yes, well, there are problems with the government water supply? Otherwise, I don't quite understand if they've got a perfectly good government water supply.
I don't want to give evidence. It's certainly not a preference.
Well, I read that as meaning they had to pay for the water rather than getting it free from the well. But we understand that Rubis actually pays the water bill. Is that still the case?
My lady, I would need to take instructions. I can't.
But at the time of they've been paying her water bill since the 2012-2013 leak.
That's certainly the evidence she gave, and that evidence wasn't challenged. Rubis didn't deduce any of its own evidence on the question.
Thank you.
Unless I can assist the board any further.
No, well, thank you, Mr. Casey. You stuck to your slightly abbreviated reply time. Well, the board is most grateful to counsel on both sides, and no doubt those sitting with or behind counsel who have assisted them. I think we're still awaiting a little bit from your junior, Mrs. Roll, about whether there's anything helpful to you in the
Chuckling
transcript.
about the local water company.
You want to say something about that now?
The only point I recognize is that at page 353, my learned friend had made an objection as to the permissible extent of the examination in chief of Mr. Boleg, and it was limited by reason of that objection. So I was only allowed to go to the conclusions and have him explain the conclusions. And that you see that at 353.
And that's all you wanted to input?
Yes, well, I had to respond to.
Yes, thank you.
Yes.
Well, as I said, we are most grateful to the work that's been done to present this quite complicated appeal in a short time. It will come as no surprise to know that the board will take time to consider what advice